Good afternoon, everyone. This is Heidi Meyers. Today, we're going to talk about if your immigration case or application is denied, what are your chances of winning in federal court? There is a very important Supreme Court decision that really affects the chances of winning on an immigration issue in federal court that you've never heard of. The reason you've never heard of it is because it doesn't specifically deal with immigration. It's called Kisor versus Wilkie. It is the case of a Vietnam War vet who filed for VA benefits in 1982, claiming that he had post-traumatic stress disorder, and his initial claim was denied. Later on, he reapplied. He made a motion to reopen in 2006, which was granted, also based on the post-traumatic stress disorder. However, the VA determined that he would only be eligible for benefits from the date of the motion to reopen in 2006 instead of from his initial claim back in 1982. So it was a question of retroactivity. So he lost with the VA, Veterans Affairs, and he also lost with the Board of Veterans Appeals and then an initial federal court that deals specifically with Veterans Appeals. So the reason this is important for immigration is because the VA and the immigration courts, USCIS, the Board of Immigration Appeals, they're all federal administrative agencies. So that's what they have in common. The VA, USCIS, Immigration Court, the Board of Immigration Appeals, they are considered federal administrative agencies. So when a federal administrative agency, such as the Board of Immigration Appeals or USCIS, denies an immigration application or denies someone's relief from removal, the way the federal court looks at that decision and the procedure the federal court goes through to analyze it is similar. So what Kisor did, the Supreme Court decision in Kisor v. Wilkie, it said that the federal courts should not immediately give deference to a federal administrative agency decision. So what does that mean? Basically, there was a case from a while back, Auer versus Robbins, that the federal courts used to say that, well, in general, most of the time, we are going to give deference to a federal administrative agency decision. What is deference? Deference means, well, you guys are the experts in that field, you're an administrative agency, we're just pretty much going to go along with whatever you all want to do. And if a federal administrative agency denies an application or the BAA denies relief from removal, pretty much the federal court's position was, well, pretty much we'll just go along with whatever you're doing or whatever your decision is, unless there was genuine ambiguity in the regulation or the statute that the agency was interpreting. But the federal courts generally tended to jump to the position that, oh, we're just going to defer, meaning we're just going to go along with the program, whatever you all decided, we're just going to go along with it. So what Kisor versus Wilkie did was the Supreme Court said, no, the federal courts don't automatically just defer. The federal courts aren't just going to automatically go along with whatever the VA decides or whatever other administrative agency, supposing the Board of Immigration Appeals or USCIS. Before the federal court defers to an administrative agency decision, first, the court has to analyze carefully whether the statute or regulation is genuinely ambiguous. So when looking at a regulation, a federal regulation, you have to analyze it just the way you would a statute, by looking at the text, structure, purpose, and history, legislative history. Okay, so you have to go through that analysis first, if you're the court, if you're the judge, and you have to make sure that the statute is genuinely ambiguous. I'm sorry, the regulation is genuinely ambiguous. So this was the first time that the Supreme Court explicitly said that the same rules of interpretation that you apply to a statute, you also apply them when you're analyzing a regulation. So that's the first thing. So first you want to determine, the court wants to determine, is the regulation, the federal regulation, genuinely ambiguous? And then even if it is ambiguous, the court also has to look at, for example, is the issue in the case an area in which the administrative agency has subject matter expertise. So, for example, you could argue that the Board of Immigration Appeals does not have any particular substantive expertise in matters of criminal law, or in interpreting what are the elements of a statute that have to be satisfied for a conviction. Another area might be tolling, or issues of jurisdiction, or issues of retroactivity. Those are generally considered within a court's purview. So there might also be an argument that the Board of Immigration Appeals does not have expertise in issues of international law or international human rights law. So this decision, even though it came up in a case involving a Vietnam War vet and the VA, the Veterans Administration, it also applies to immigration cases because, like I said, they're both they're both administrative agencies. So this is a very helpful Supreme Court decision, which can be used if you need to go to federal court and appeal a denial of your immigration application, suppose a denial by USCIS, or if you are denied relief from removal by the Immigration Court and the Board of Immigration Appeals. So that's it for today. Thank you very much. This is Heidi Meyers, Immigration and Economic Sanctions Attorney. I'm at 11 Broadway, Suite 925, New York, New York, 10004. My phone number is 212-791-4007 or 646-508-5225. And don't forget to like this video and subscribe to my channel. All right, thank you very much. Bye-bye.